Well, first of all, I'm actually in jury selection in the 339th. I'm picking a non-death capital case, and I'm due to be back at 2 o'clock. So let me start out by saying this. In 1985, I came to work in the Harris County District Attorney's Office. I had come from Tarrant County in Fort Worth, and my first trial was in front of Judge Hendricks. Now, most of you wouldn't remember him, but let me just tell you what happened. As I was getting ready to pick the jury, my chief came up to me and she asked the following question. She said, "What is your position on putting blacks on your jury?" Now, I had just come from Cowtown, Fort Worth, which is as redneck as it gets. But I had never been asked that question before, and I was taken off guard, and it is usually a very, very unusual circumstance for me to be speechless. But I had to step back for a moment and think about the question and how, to me, how stupid it was. And I paused and said, well, I don't have a position save and except that when I examine a prospective juror, I'm looking for someone who basically is going to see the case my way, that's going to be fair and impartial to me. I didn't have a more sophisticated answer than that. And I'm not good at and don't like dropping names, so I'm not going to tell you who my chief prosecutor was. Suffice it to say, her initials was Pam Derbyshire. And that's all I really want to say about that. But what it told me and what it alerted me to is this. For whatever reason, there is a built-in prejudice that really believes that certain groups, and you're going to have some lawyers talk to you about how Batson has actually expanded to a religion, gender, and some other areas, but there is an inherent belief that a lot of people unfortunately hold that certain groups, and Batson to this, are one of two things. They're either incompetent or they are perceived to be prejudiced in favor of one side or the other. Specifically, when it comes to blacks, there is this belief that if there's a black defendant, that juror necessarily is going to see it in a sympathetic eye toward the defense. Let me give you another example, and let me tell you why that is so untrue. Joe Salhab, who you know is recovering from a brain aneurysm in the hospital, he and I tried a capital case in Judge Cosper's court where the state was seeking the death penalty. And at the punishment phase of the trial, the jury deadlocked on the issue of mitigation. And you know when a jury deadlocks, that means your client automatically is going to get a life sentence. So we were really, really happy. And they said it was 8-4. 8 of the 12 jurors did not see mitigation, and they wanted death. I had 4 blacks on that jury. And I said to Joe, I said, now this is going to be the reason going forward that the prosecutors are not going to. When Judge Cosper discharged the jury, we went in the back and talked to them. And all 4 of them looked at me and said, and I'll never forget this, they said, Mr. Nunnery, we were not buying that bullshit that you were talking about mitigation. They said, your client deserved to die. And I mean, I was hurt. I was stunned. But that was their perspective, because basically what they were saying, the things that you were talking about are things that we all face on a daily basis. And of course they said, I didn't commit capital murder, so I don't see why his poor household, his mom was a heroin addict, meant a thing to them. So what I'm saying is the perception is so wrong. With that in mind, I want to ask this question. How many of you have actually, in your practice, raised a Batson challenge? Raise your hands high. Raise your hand, and they're not that many. How many of you have had a successful Batson motion granted? Okay, I see 4. Okay, and Eric, that's 5. Again, I've been practicing since 1920, wow. 1990. And in my practice, I have only had 5 successful Batson challenges. So if you spread that out, that's about 1 every 4 or 5 years, okay? That doesn't mean I haven't raised it more often, and I'll talk about that in just a moment. But it's a difficult motion to win. The one judge I know, Judge Patrick, Ryan Patrick, he's not here yet, is he?
No.
Okay, good. So there are no judges here, right? Okay. So let me tell you why I think there's difficulty before I talk about how to do it, okay? When you raise a Batson challenge, it's a chill that comes across the court. And it's not really just the prosecutor who's pissed off, but the judge. And in fact, the judge seems even more angry than the prosecutor that you have the audacity to stand and make the motion in the first place. But one of the things I've learned over time is I don't expect the prosecutor to be my friend, but I certainly do not expect the judge to be an advocate. But the reality of the situation is this: they almost take it as personal as the prosecutor. I don't know what lurks in the hearts of my adversary, i.e. the prosecutor, and at the end of the day, I really don't care. They get very, very angry when you do it. How dare you? You're calling me a racist? No, I don't know what you are in your regular life. All I'm simply saying is, based upon the record and based upon what I see, I think you have, in this case, engaged in race in using one of your perempts. So here's the first issue. You cannot care what the judge's perception of your raising that motion is. Skip Cornelius, by the way, he does this even before voir dire. It's not a written motion. He just gets up and this is what he says. He said, "Judge, I just want the record to reflect that I intend to raise a Batson challenge if the prosecution engaged in striking their jurors on the basis of race." So he is at least giving them notice that it's forthcoming for whatever it's worth. And I don't know if that causes them to redirect what they're about to do or not. But here's some logistical things I want to talk to you about, first of all. One, when you get your jury information sheet, the first thing you should do, oh, and let me back that up a little bit. Long before you do this, at least during jury selection, if it is possible, I think it's incumbent upon every last one of you to go pull somebody to sit with you during jury selection. Right. Because it's so important, because we'll talk about this a little later. You're going to be trying to compare some of the things, if the judge agrees you've made a prima facie showing, to what the prosecutors are responding to. And it's very, very hard to look back sometimes and say, well, you said you struck this juror based upon A, but then you find out later that there was someone with that same characteristic that they didn't strike. So I think it is very, very important that you pull someone in, okay? I don't like to call names, but my angel at voir dire is Michelle Beck. I don't care where she is. I try to go grab Michelle to sit with me. First of all, she can take notes better than I ever can, and I just completely rely on her note-taking. But that's, first of all, it's important. The second thing is, if you have a black defendant or if you have a Hispanic defendant, Asian defendant, or whatever that group subject to discrimination might be, you should note on your chart their race, okay? If it's black, go through your 65, put BBBBB wherever you need to, HHH, Hispanic. And of course, as they kind of extended this now to gender and to religion, I mean, you need to start noting those things too, because the the Supreme Court has said that these are protected classes also. So that's the first thing. Then the second thing is, and this is really, really important, throughout the voir dire, you got to be very, very attentive to what's going on. First of all, let me say this. These prosecutors are much smarter in Harris County than maybe that guy in Montgomery County just recently. And they're a little more subtle, a little more devious, and a little harder to pull some of this out, okay? One of the things that I've noticed now is I think they have what I call race-neutral questions that have been tested over time. For example, I'm in trial right now, and the question is to rank a police officer 1 through 4, 1 being you respected, but you're not really, a big fan, all the way up to 4, okay? And of course, when we get to the argument about why you struck them, the ones that were 1 and 2, and by the way, more often than not, blacks are going to fall in that 1 or 2. Well, on the face of it, that looks like a race-neutral reason, right? But in reality, when you think about the disparate impact that that has, they can fall back on that and say, Judge, I did not strike him because he was black. I struck him because he was not high on law enforcement officers. So you need to start trying to pull that in. One of the other questions I submit to you that is not race neutral, but on its face they offer it as such, is the question about punishment in general. Do you believe that the purpose of punishment is punishment or rehabilitation? Well, that question I suggest to you has been tested over time. Most black folks have a sense of redemption and second chance. So they might say rehabilitation. And again, that gives them the opportunity to say what I've just done is not racial. So you really need to know who your prosecutors are, and you need to start raising those issues. They often are not going to get you anywhere, but who cares? I think you need to at least keep that in so that records over time can be developed, okay? So now you're in the process, and this is what Eric has asked us to do. The list is in, and the panel has been, oh, and one other question. Every now and then, and it's mandatory according to the code, that the jurors actually check their racial identity. Sometimes those boxes are left empty. Ultimately, you could rely on the judge, I guess, making a judicial determination that the person is black, but sometimes you may want that record to be clear because sometimes that box is left unchecked. But here's the process. The judge has now seated that jury. Be very, very careful. Do not let that jury be excused because sometimes the judge will not ask, are there any objections? Or they may say, is there anything further? You need to be very proactive and immediately say, Judge, I need a moment. You then need to go back and check your list and then ask to approach the clerk and get the state's strike list. For your Batson hearing, make that state's checklist an exhibit, okay? And then you need to look at that list and see who in that 32 available jurors were black or Hispanic, depending upon what your challenge or your focus is, and to see how many strikes the state used. And see, here's the key to that. Let's assume in the 32, there are only 3 blacks left, okay? And they strike 2 of them, okay? So they have used what? What is 2/3? 66% of their 10 strikes 2 of their strikes to eliminate 66% of the available blacks that are still left to qualify. That quantitative analysis alone is sufficient to raise a prima facie showing that at least at a minimum ought to cause the court to tell that prosecutor, then you need to justify why you engaged in or why you struck those jurors. So it's very, very important that you have that checklist with you. Then once the state starts lying, which is what they're going to do, you need to be proactive to try to prove that those are pretexts, which the case law allows you to do in order to sustain your Batson challenge. Now let me give you some examples, and I think this may shock you. One of the Batson challenges that I actually had granted was from Judge Crocker. And we had been in voir dire for like 10 hours that day. It was a lot of co-defendants. And the prosecutor, all the lawyers agreed they were going to let me do all the voir dire. And the prosecutor, and I don't remember who that prosecutor was at the time, said, Judge, the reason why I struck so-and-so, so-and-so, so-and-so is because when Mr. Nunnery got up, I saw those prospective jurors smiled, and they seemed to like him. And I don't think I'm that funny, but they were laughing when I was talking to them. And Judge Crocker said, "Are you serious? Are you going to tell me that you struck those jurors because you say they smiled at Mr. Nunnery?" And needless to say, now the record is silent as to who the hell is smiling or not, and how do you disprove that? But Judge Crocker said, absolutely not. She said, I am going to grant the Batson challenge. I am going to, and there are two remedies, by the way. The constitutional remedy says that you seat that juror who was impermissible